United States attorneys represent the United States federal government in United States district courts and United States courts of appeals. The prosecution is the legal party responsible for presenting the case against an individual suspected of breaking the law, initiating and directing further criminal investigations, guiding and recommending the sentencing of offenders, and are the only attorneys allowed to participate in grand jury proceedings. There are 93 U.S. attorney offices located throughout the United States. Puerto Rico, the U.S. Virgin Islands, Guam, and the Northern Mariana Islands. One U.S. attorney is assigned to each of the judicial districts, with the exception of Guam and the Northern Mariana Islands where a single U.S. attorney serves both districts. Each U.S. attorney is the chief federal law enforcement officer within his or her particular jurisdiction, acting under the guidance of the United States Attorney's Manual. They supervise district officers with as many as 350 assistant U.S. attorneys and as many as 350 support personnel. An assistant United States attorney, or federal prosecutor, is a public official who represents the federal government on behalf of the U.S. attorney in criminal prosecutions, and in certain civil cases as either the plaintiff or the defendant. In carrying out their duties as prosecutors, AUSAs have the authority to investigate persons, issue subpoenas, file formal criminal charges, plea bargain with defendants, and grant immunity to witnesses and accused criminals. U.S. attorneys and their officers are part of the Department of Justice. U.S. attorneys receive oversight, supervision, and administrative support services through the Justice Department's Executive Office for United States Attorneys. Selected U.S. attorneys participate in the Attorney General's Advisory Committee of United States Attorneys. The Office of the United States Attorney was created by the Judiciary Act of 1789, along with the Office of Attorney General and the United States Marshal's Service. The same act also specified the structure of the Supreme Court of the United States and established inferior courts making up the United States federal judiciary, including a district court system. Thus, the office of U.S. Attorney is older than the Department of Justice. The Judiciary Act of 1789 provided for the appointment in each judicial district of a person learned in the law to act as attorney for the United States, whose duty it shall be to prosecute in each district all delinquents for crimes and offences cognizable under the authority of the United States, and all civil actions in which the United States shall be concerned. Prior to the existence of the Department of Justice, the U.S. attorneys were independent of the Attorney General, and did not come under the AG's supervision and authority until 1870. With the creation of the Department of Justice, the U.S. Attorney is appointed by the President of the United States for a term of 4 years, with appointments subject to confirmation by the Senate. A U.S. Attorney continues in office beyond the appointed term, until a successor is appointed and qualified. By law, each United States Attorney is subject to removal by the President. The Attorney General has had the authority since 1986 to appoint interim U.S. attorneys to fill a vacancy. The governing statute, 28 U.S.C. Section 546 provided, up until March 9, 2006, a person appointed as United States Attorney under this section may serve until the earlier of the district court for such district may appoint a United States Attorney to serve until the vacancy is filled. The order of appointment by the court shall be filed with the clerk of the court. On March 9, 2006, President George W. Bush signed into law the USA Patriot and Terrorism Prevention Reauthorization Act of 2005, which amended Section 546 by striking subsections and inserting the following new subsection. A person appointed as United States Attorney under this section may serve until the qualification of a United States Attorney for such district appointed by the President under Section 541 of this title. This, in effect, extinguished the 120-day limit on interim U.S. attorneys, and their appointment had an indefinite term. If the President failed to put forward any nominee to the Senate, Then the Senate confirmation process was avoided, as the Attorney General appointed interim U.S. Attorney could continue in office without limit or further action, related to the dismissal of U.S. Attorney's controversy. In March 2007, the Senate and the House voted to overturn the amendments of the USA Patriot Act to the Interim Appointment Statute. The bill was signed by President George W. Bush and became law in June 2007. Senator Dianne Feinstein summarized the history of interim United States attorney appointments on March 19, 2007 in the Senate. When first looking into this issue, I found that the statutes had given the courts